If you're married and you're not getting support and you're separated or you're about to go through the divorce process, the only way you're going to really get that is by initiating a divorce action. There is something else called separate maintenance. We won't cover that today, but I guess the short answer is you're going to have to establish or initiate a legal proceeding. So it's best to just talk to whatever lawyer you can in your area. And like I said, you might be able to qualify for something like Department of Revenue, which is free services for just the issue of child support. Okay, so what happens if, and I deal with these cases too, there is a court order establishing child support and dad's just not paying, violating the support order. That's a situation where, again, depending on if you qualify or not, you can use DOR or you'd have to go through your private attorney, but you would be filing a motion for contempt and or enforcement. So you're asking the court, you're basically saying to the court, hey, I have this document that says dad needs to pay child support and he's not paying. And I want to hold him in contempt to kind of force him to start cooperating so he doesn't have to be fined or sanctioned or possibly incarcerated, paying attorney's fees. They're like punitive in nature. We want to punish somebody to make them do what they need to do. Or B, just enforce it. Force him to do this, like reinforce it. So that's a whole other legal process in and of itself, and we do handle those types of cases. That's what we would call a post-judgment matter, meaning we've already got the order or we've got the final judgment, and it says party A is supposed to pay party B for child support. If they're just not paying, that's when you would initiate the post-judgment issue or action to get contempt and enforcement issues. The other thing that I wanted to cover in this, we talked about what is child support, how do you get it calculated, what's included, what's not included, how to start the process. Another thing that we get asked about a lot is back child support or retroactive child support. And again, this will be different depending on what state you're in, but in Florida, the general rule or the law under the statute is that we can apply child support to go retroactive, going backwards, as much as 2 years from the time the parents did not live together. So if there's a separation between husband and wife, and the husband hasn't been paying child support, I always pick on the husband. If one parent's not paying child support to the other, and they should be, or they should have been, then that parent that should have been collecting can go back and seek retroactive child support for as much as 2 years from the time that they were not living together. That does not mean that paternity cases are the same situation. So we have cases, for example, that are pending right now where we're asking for child support to go back all the way to the child's birth because parent A should have been paying, let's just say, $500 a month in child support. And if they were not paying for, let's say, 2 years, then 500 times 1 year is $6,000 times another, that's $12,000 in back child support that would be owed from the parent that should have been paying. So you can seek retroactive support. It depends on what kind of case you're dealing with that is available. Any other questions? All right, so I think we covered a good amount. That's the basics for child support. Hopefully that was helpful. Again, it's different state to state. If you have any questions, you can feel free to email me, Taryn@sinatralegal.com. And we've recorded this so you can always reference it for future reference if you need to. Next time, I think we're going to be talking about alimony, which will be a really interesting issue considering that we have a new alimony bill that is probably about to be passed by the governor here in Florida. We're all kind of waiting on pins and needles to see what's going to happen with that. And thank you guys so much for joining.